Hello, ethical and legal issues in engineering. So here you can see the learning outcomes of this lesson. At the end of the lesson, you should understand the meaning of morals, ethics, and values. Understand what a patent is and um, filing criteria of the patent and elements of patent. Understand differences between patents, copyrights, trademarks, and trade secrets. Understand the concept of negligence and liability as they apply to product design. These are legal issues in engineering design. Okay, let's start with some words, values, principles, and morals. Values are the things that a person or a group of people believes to be valuable or worthwhile. On the other hand, principles are some fundamental laws that may govern people's behavior. As you might know, golden rule says that treat people as what you like to be treated. Finally, morals are simply the things that are right and wrong, usually derived from principles. So these three words are important in engineering design and very much related to ethical issues. So let's define ethics. There are two definitions taken from dictionary. One is about a branch of philosophy. On the other hand, in engineering or fashion, we can define ethics as rules or standards governing conduct, especially those of a profession. So we will be focusing on this definition of ethics. There may be different ethical systems. Here you can see three major types of ethical systems. The first one is rule-based ethics, where we apply a set of rules to make all decisions regarding with the society. Thus, two properties or principles of rule-based ethics are important. Universality, where all people in society accept reasons or actions. Transitivity, here we simply accept others when they apply the same decision to you. In rule-based ethics, society, almost all members agree upon the rules. There is no exception, usually, when we apply rule-based ethics. On the other hand, conditional rule-based ethics, we have some certain conditions where some individuals can break a rule. An example could be the case where we transport an injured person to a hospital, and we may have speed limits, but we can exceed speed limits in order to catch the person's health and transport the person to the hospital as soon as possible. So this type of breaking rules would be possible if we have some we have an ethical system where we have conditional rule-based ethics apply. Finally, utilitarian ethics. The decision here produced highest good for all people. So here, this highest good is questionable. The highest good would be good for some of the people, but may not be good for others. So there may be an ambiguity here, and this is usually considered the poor ethical decision system. Okay, here you can see an universally accepted code of ethics by IEEE. I'm sure that you are familiar with IEEE, and some of you may be student members of IEEE. I'm a senior member of IEEE, so I know organization. Events organized by good professional organization. Here you can see 10 rules. The first one is accept responsibility in making engineering decisions. So decisions should be consistent with the safety, health, and welfare of the public. The second, avoid real or perceived conflicts of interest whenever possible. If you have any conflict with others, then you have to disclose this so that the affected parties they do not exist. We have to be honest and realistic in stating claims, making some estimates based on some available data. Reject bribery in all its forms. It's a very common problem in developing countries. Bribery, it's popular in many of the professions. Next, to improve understanding of technology and its appropriate application and potential consequences. To maintain and improve our technical competence and to undertake technological tasks for others. If there is a limitation, we have to disclosure limitations. To seek, accept, and offer honest criticism of technical work. Have to acknowledge errors, credit properly the contributions of others. To treat fairly all persons, regardless of such factors, race, religion, gender, disability, age, or nation origin. This is quite common in almost all professions. To avoid injuring others, their property, reputation, or employment. Also are mentioned. To assist colleagues and co-workers in their professional development. And we have to support them in this code of ethics. So these are quite common universally. With IEEE, I'm sure that you come across this somewhere in the events organized by IEEE. Okay, it was about ethics that we have discussed. Next, let's see patents. Patent is a legal protection for a design or invention. As engineers, we may produce a design or we may invent something new and to try to protect those invention or design. And patent is the most common tool or legal approach to predict our design. There are two types of patents: utility patent and design patent. Design patent is rather about the visual qualities of an item. Usually it's about the configuration or shape of the item. So it's just about better for arts, crafts. On the other hand, utility patent is quite applicable to engineering and so information. It's about functional aspects of an item. Usually it takes longer time to this type of patent. A patent must have three elements. As you can see here, it should be novel, it should be non-obvious, and it should be useful. Okay, here in the next three slides, I'll be sharing some documents, which are common when we apply Turkish Patent Institute for filing a patent. On the right-hand side, the top, you can see application process, the documents that we have to submit, application form, a fee, and the definition of the invention, claims, abstract and figures. These are the components of the patent application, or what we call faydalı model. Okay, on the bottom you can see three words: yenilik, buluş basamağı, sanayi uygulama. These are just about novelty, non-obvious property, and usefulness. We have to have something new so that the patent should have novelty. On the other end, non-obvious, that's the requirement that if a technical person look into your patent claims, that person could not easily see that claim, right? So this somehow requires understanding of state of the art and try to develop something or invent something which is not visible, easily seen in the state of the art. And it should be useful. We have to apply patents to somewhere which could be important for human. Here you can see the difference between patent and what we call faydalı model. The three requirements here is important. Yenilik, buluş basamağı, sanayiye uygulanabilirlik. So what we call novelty, non-obvious, and useful. As you can see in faydalı model, we do not have non-obvious criteria. We only need the two criteria, novel and useful. Okay, so the major difference is about this non-obvious criteria. It's applicable to patent, but not to faydalı model. There are also some other criteria here. You can see this in this table. So here there's a flow for TPE, Turkish Patent Institute. You can follow this flow when you want to apply or when you want to file a patent. Here you can see elements of the patent, citation of prior art, description of the invention, and claims. So these are the legal description of the invention and its uniqueness. Here you can see 3 websites: US Patent Office, Turkish Patent Office, and European Patent Office. These are government organizations who want to file a patent in US or Europe or Turkey. You have to follow the directives of those organizations. So let's see the elements of the patent. Here you can see one of the patents that I have filed about 5 years ago. You can see citation to prior works here, the domain name, what we call tarifname. And in English, here you can see a patent from US PTO. It's about intrusion detection and radio fingerprint tracking. And you can see here the citations to prior patents. So which patent application should have citations to prior works so that we can understand that your patent or your ideas are new or novel. Next, we have description of invention. We give by some figures the details of our invention. There are usually a standardized approach wording follow when we are writing a patent. It's in Turkish and it's English version, detailed description, as you can see. And finally, we have claims. These are the patent. It's just about the subject or ideas, novel ideas that need protection by the patent. So we simply try to protect these ideas, these claims. The major motivation in filing a patent is to protect these claims. These are usually technical words or writing that could be carefully written. In English version, you can see the invention claim. 1, 2, 3, 4 goes like this. Higher the number of claims, better to cover the subject. So try to protect your idea. So here, once you apply or file a patent, there is a procedure that you have to follow, and we have shown that previously, TPE flow. And suppose that all your documents are incorporated, you file your patent, and the feature to be followed. At the end, you may have a response from the TPE decision document. Usually we have a patent company that we work together. It's not easy to prepare a patent. This has many non-technical issues that we may not be familiar. So it's better to get some help from some professional companies. So this is the patent that I have applied, and the response was sent in 2019, so 3 years ago. It was an application, goes back to 2014. So after 5 years, I was able to get a decision that one. At the end, a certificate was issued and sent to me. You can see the patent number here. This is issued by the TPE, and you can see the patent owner here. Actually, owner is me, but I transferred the license ownership to Atılım University, for which I was working at the time of the patent filing. But all patents are somehow belong to people. People can transfer their rights to organizations. Okay, next, let's see copyrights and trade secrets. I'm sure that you are familiar with copyrights as you frequently use textbooks. That's a protection method for published works, like books, articles, and software. So you may use a software or article or a book, and this copyright simply protect your work to be distributed by others. On the other hand, trade secrets are simply alternative to patents, make the invention or method not to be made public. So there is usually an agreement, what we call non-disclosure agreement, NDA, and we have to do this agreement with people who work with us so that they will not share any information with others. Okay, finally, let's talk about legal issues in engineering, and there are three words that I have to talk about. Liability, what we call in Turkish sorumluluk, something that one owes, an obligation or debt. So this definition. Third, that's a wrongful act, though not necessary to be illegal, of course. And negligence, not following reasonable rules and standards. Usually that can be applied to engineering, design, or a device system. That's usually a failure, actually, to give enough care or attention to someone or something that we are responsible. What we call in Turkish, ihmal. So, sorumluluk, haksız fiil, ihmal. These are the words that we have to be familiar when we have a device that we design, and then when we sell this device to people, the user or customer, and then we'll have some responsibilities. And liability, tort, and negligence are the words that we may come across. Legally liable for negligence, so what we call in Turkish, ihmalden hukuken sorumlu olmak. So here it must be shown that the manufacturer did not follow some standards and rules that apply to the situation and committed a wrongful act. Any manufacturer, so we might be as engineer or responsible, legally liable if the following conditions are true. The manufacturer had a duty to follow reasonable standards and rules. There was a breach of duty, the failing to include safety devices, and plaintiff was harmed, and the breach caused the harm. So this four conditions hold true, and the manufacturer will be legally liable. And there is strict liability, what we call Turkish sorumluluk. That's rather on the product, and the person or company suing you does not have to prove negligence here. And we as engineers might be strictly liable if the following four conditions are true. The product was dangerous and or defective. The defect existed when it is left to the customer, to the user. Defect caused harm, and the harm is assignable to the defect. Okay? So that's about the product simply. When we develop a system, when we develop a device, and produce it and sell it to users or customers. We have to be careful. We might be strictly liable. We contributed to the design or production. So in the projects, especially in senior design projects, description document that must be prepared by the students at the end of the semester. In that document, we simply try to help the customers or users to know about the product, the details of the product, and this may help us to avoid such strictly liable cases.